Welcome everyone. Thanks for joining us today for this important conversation. I'm going to give about 2 more minutes for everybody to log on, and then we'll get started. Welcome everyone. We'll get started very shortly. All right, I'll go ahead and get started with some introductions. So welcome everyone. My name is Katie O'Connor, and I'm the Deputy Chief Counsel at Demand Justice, an organization fighting for progressive change in our courts. Thank you all for joining us for this important conversation about the upcoming Supreme Court case, United States versus Rahimi, and the future of efforts to prevent gun violence and domestic violence. I want to start by thanking our partners, Brady United Against Gun Violence, the National Coalition Against Domestic Violence, and Giffords Law Center. We are so lucky to be in this fight with you all, and I'm really looking forward to this conversation. I won't waste too much time before getting to you all, the real experts, but I thought I'd just start with a very brief synopsis of what this case is all about. Just last year, in a case called New York State Rifle and Pistol Association versus Bruin, the Supreme Court announced a pretty sweeping new interpretation of the Second Amendment. They called into question decades of common sense laws that seek to prevent gun violence in the face of our country's escalating gun violence epidemic. One of those laws prohibits the possession of firearms by someone who's subject to a domestic violence restraining order, reflecting Congress's understanding that domestic violence is pervasive, deadly, and inextricably linked with firearms in this country. The lower courts had affirmed the constitutionality of this law as recently as 2020, but following Bruin, the U.S. Court of Appeals for the Fifth Circuit struck down the law as a violation of the Second Amendment. The case is now before the Supreme Court, and the court's likely to rule on the constitutionality of this life-saving and eminently reasonable law by next summer. I'm thrilled to be joined by 3 super smart people who can help us break down what this case is all about and what it might mean for domestic violence and gun violence prevention in the future. So now I'll introduce my wonderful panelists. We are joined by Shira Feldman, the litigation counsel at Brady United Against Gun Violence. We're also joined by Ruth Glenn, CEO and president of the National Coalition Against Domestic Violence. And finally, we're joined by Esther Sanchez Gomez, litigation director at Giffords Law Center. Let's go ahead and get started. I am going to be directing questions to you all individually, but you should all feel free to weigh in whenever you'd like. And I do plan on getting to some audience questions at the end of the hour. So if you're in the audience and have a question, feel free to go ahead and put it in the chat or in the Q&A function, and we'll get to it later. So Ruth, I'm going to start with you. Can you tell us about the pervasiveness of domestic violence and the history of efforts to address it? Ruth, you're on mute.
I do it all the time. All the time. First, I'd like to make just a minor correction, a small correction. Just recently, I am now the public affairs president for the National Domestic Violence Hotline and the National Coalition Against Domestic Violence. So it is a switch, and just wanted to make sure that there was some clarity to that. So first of all, I'm so pleased to be a part of this, and certainly with Shira and Esther talking about what is really, really important. The pervasiveness of domestic violence is a public health crisis. Always has been. We are seeing it in ways, of course, you know, with the 20th century and how it's done by perpetrators of abuse, and that is really concerning, but it has never stopped being a public health crisis. We are always concerned about, for instance, this new era we're in where firearms are so accessible and technology is so accessible that we're seeing perpetrators use those more so than ever, of course, because they have access to that as a tool for control. So definitely concerning in regards to the Rahimi decision, and even as far back as Bruin, and what are we going to do about that? Because we do not want to provide more tools, access to tools that are used for power and control in domestic violence situations.
Thanks, Ruth, and sorry for getting your title wrong.
No apologies, it's new.
Shira, I'm going to turn to you next. This case in particular is about a federal law that prohibits the possession of firearms by somebody who's subject to a domestic violence restraining order. This is a law that I think would seem to most of us entirely common sense. So before we get to the argument being made against this particular law, can you talk about how we got to the point where a law like this would even be challenged in the first place?
Yeah, absolutely. And thank you so much for having me. It's such a pleasure to be here. So we need to go back a little bit to figure out how we got here. For most of the history of the United States, the Second Amendment was understood to be a collective right. And if you read the full text of the amendment, which I'm sure many of you are familiar with, it says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And courts really understood that to be about this militia, this collective right. And we see that, just to give an example, in a 1939 Supreme Court case, United States versus Miller, where there was a challenge to the National Firearms Act of 1934, partly on Second Amendment grounds. And the Supreme Court made very clear that the militia part of that language was very relevant. But we get to 2008, and we get the Supreme Court's decision in District of Columbia v. Heller. Now, that case was a challenge to the District of Columbia's ban on handgun possession. And the court struck down the ban, but it also did something maybe more important and alarming, which is that it said that the controlling part of the Second Amendment is the right of the people to keep and bear arms. And it says that this means that there's an individual right to keep and bear arms for the defense of hearth and home. So after Heller, trial and appellate courts aren't sure how to analyze Second Amendment claims. They have to figure out how to do that. And they ultimately settle on a framework that's based on how courts analyze a lot of constitutional rights. Under the framework, you first ask whether the law being challenged imposes a burden on the conduct that you want that is within the scope of the Second Amendment. Does the Second Amendment actually cover this conduct, and how much of a burden does it cause? And if it does, you apply what's referred to as scrutiny. You ask what the government interest is that's being advanced, whether advancing it is being done in a narrow way. We understand that constitutional rights are important, but there's interest balancing that has to happen. And under that framework, until last spring, a lot of gun laws were upheld as constitutional by the courts. But then, as you said, Katie, last year, we got this decision in June in New York State Rifle and Pistol Association versus Bruin. The case was a challenge to New York's concealed carry permitting scheme, which was a law that had been around for about 120 years. And you could not get a permit under that law to carry a concealed weapon without what was called a special need to do so. So the New York affiliate of the NRA challenged the law, and the court struck it down, but it didn't just strike down that law. It also rejected the test that I just described for how to analyze Second Amendment laws. And it said that you can't have interest balancing anymore. You can't look at what the government interest is that's being advanced. Instead, you have to look at two steps. Under the first step, you ask whether the conduct is within the plain text of the Second Amendment. And then if it is, the government, which is defending the law, has the burden to put forth evidence of a historical tradition of firearm regulation that is analogous or relevantly similar are words that the court uses to the law that's being challenged in the present day. Now, very importantly, the court in laying out this test said a couple of things. One, it said the law has to be analogous, but it also said that it doesn't have to be a twin. You don't need a historical replica of the law that's on the books today in order for it to be constitutional. And the court also gave some guidelines about how you determine what's analogous. It referred to these as two metrics. And those metrics are that you look at the how and the why of the present law and of the historical law, and you compare those two things. And the court also says that when you have new societal problems, new technological advances, you have to take a nuanced approach to this analysis. But to be clear, this upended all of the previous analysis of the Second Amendment that courts had been conducting. And so all of a sudden, all gun laws essentially were being challenged.
Okay, well, with that, Esther, I'm going to move on to you and ask, so now that we have to analyze regulations on firearms consistent with the Supreme Court's interpretation in Bruin, can you talk about the historical underpinnings of the law that's at issue in this case?
Sure, and very pleased to be here with you and with Ruth and Shira. Really appreciate their perspectives. And I think I'll start by jumping off on something that Shira was talking about, which is that the Supreme Court did announce this massive shift in the methodology, but it did so without overruling Heller. And I think it's important to remember that, because while the court sort of changed everything, it also said that it was doing so under the same umbrella concept. And, you know, in going through history and this new methodology, we're always sort of confronted with squaring what the Bruin court did and what the Bruin court changed about the Second Amendment, which was already new in 2008 when Heller was decided, as Shira explained, with what Heller said, and sort of the jurisprudence that flowed from Heller, and a lot of the sort of language about laws that were definitely going to withstand scrutiny under any interpretation of the Second Amendment. And the other piece that I want to mention is that even with this massive shift, and specifically in Bruin, the court did take great pains to mention how narrow the ruling was on the facts. Shira mentioned this proper cause standard that was struck down. And so I think that, to sum it up, basically the court took massive steps, but at the same time tried to reel it back and say, we're changing everything, but don't worry, not everything is changing, which is really difficult for the lower courts to make sense of. So to talk a bit about the history of the domestic violence restraining order prohibitor, obviously this is a relatively new law, part of the Violence Against Women's Act, but you know, domestic violence is not new to our society. And the notion of disarming people who we see as a threat to society or to individuals is also not new. And so a lot of different historical references were submitted to the court. There's no chance that we would be able to talk about all of them, even if we stayed here for 5 hours. So I'm going to talk about just sort of a few categories of laws that, you know, were presented to the court and that the court talked through. I won't dive in too much into what they did with them. I think we'll talk about that a bit later. But we're talking about hundreds of years of history dealing with firearms regulation. And I think that the fact that there are hundreds of years of history of firearm regulation is pretty telling of you know, scene setting here. But, you know, we can talk about everything going back to the Militia Act of 1662, which disarmed people that the Crown, and here we're talking about the British Crown, deemed dangerous. And then we can move forward into the colonial period, where we talk about groups that were that, you know, again, society deemed dangerous. These were categorizations that to us now would be not acceptable in the society that we live in today. These are people who failed to take oaths in favor of the government, people who were enslaved, Native Americans, people that society in power deemed to be dangerous. But these were based on, you know, groups, classes, people, based on, you know, unscientific and, you know, antiquated ideas about who was safe and who was not. these were not individualized determinations, this becomes relevant to the court's analysis. But I think it's worth mentioning that in the particular law that we're considering in Rahimi, the domestic violence restraining order prohibitor, there is due process, there is notice and opportunity to be heard, which is what's required, in our legal system for the deprivation of a number of different rights, including your right to freedom. That's what you get before you go to prison. And it's an individual adjudication and it's time bound. That is to say, a domestic violence restraining order does not disarm you for life. It disarms you for a specified period of time where the risk is greatest. So the court looked at that law. The court also looked at alternative drafts of the Second Amendment. I think that another big category of laws that's been super relevant in a number of cases, both in Bruin, it's relevant in Rahimi, and it's irrelevant in a number of Second Amendment cases that are coming through the courts, is this idea of surety laws. And these are much closer to the sorts of laws that we're talking about here, where there was an individual adjudication. Essentially, if someone thought that another person was going to be dangerous with a firearm, the person who was sort of accused of this dangerousness would have to present themselves before a court, and the court could determine to disarm them or require them to post a bond in case that they ultimately did, the dangerous thing that we were worried about them doing. When we talk about sort of how these evolved through our legal system, I think it's also relevant to mention that while domestic violence as a standalone societal concern was maybe not dealt with in the way that we did today, and I alluded to this at the beginning of my comments, domestic violence is something that has been addressed by society in various ways. Obviously, women were not empowered in society to advocate for themselves in the way that we are today. But when we talk about a community where folks were living in much closer quarters, we're talking about, relatively rural society compared to where we live today, and much smaller communities. When an individual was harmed by another individual in that community, the rest of the community was tasked with picking up the pieces of the harm that was felt by that individual. And so domestic violence a lot of times was actually seen as a crime against the community as opposed to a crime against an individual, and was dealt with in that way. Obviously not to the degree that we would like. It is a pervasive problem that has been harming many people throughout society, including women and children. But I think it's relevant because even if domestic violence wasn't associated with firearms in the way that we now know statistically it is, and the risks associated with firearm access in the domestic violence context in particular, our society has been dealing with independently both firearms and domestic violence in varying ways throughout history. And the court's treatment of that, just to preview, was interesting and sort of nonsensical in my view. And I'll leave that to future discussion. I know that we're going to talk about that a little bit later, so I'll pause there.
Thanks. I think that segues pretty nicely into my next question, which is for Shira about, how the person challenging the law responded to all of this historical context that Esther just laid out for us, and how did the Court of Appeals end up ruling in his favor despite all of that historical context?
Yeah, so I think first of all, the main thing that Rahimi and his lawyers focused on was that, according to them, domestic violence has long been a widely acknowledged social problem, as Esther just explained. But they zoom in on the fact that these specific laws didn't exist in 1791. And they make a number of other arguments as well. They say that the surety laws were not as burdensome as the law that is at issue here is. They also point out that the surety laws are from the period around the Civil War, and according to them, that's actually too recent. They think you need to go back even further. But really, I think what we see as this critical issue is they're saying we didn't have exactly these laws before. And that really reflects the problem we're seeing more broadly with Bruin, which is that challengers and courts are saying that a law isn't constitutional because it doesn't have an exact replica from the 18th or 19th century. And In addition to the fact that that's obviously very problematic for a modern society, that's not actually what Bruin requires. It doesn't require that replica. But the court in the Fifth Circuit in this case, their reasoning really demonstrates that problem, because they acknowledge that there's a history of excluding categories of people, as Esther referred to, from possessing firearms. But they say that those laws aren't relevantly similar. And one of the reasons that they say that is that they say those laws were about protecting societal order as a whole, whereas the domestic violence prohibitor, according to them, is only about protecting individual people. Now, aside from the fact that that doesn't seem like a reason to find the laws so dissimilar as to not find this one constitutional, it also tells us something about the court's view of this, which is that it's saying that protecting an individual from an abuser isn't part of the interests of society as a whole. And I think that's a really sort of stunning statement.
Yeah, thank you for that. We're going to get back in a minute to sort of the weird ways that the courts have been dealing with history in these cases. But first, Ruth, I want to ask you, guns are, as we know, uniquely dangerous in the hands of domestic abusers, and domestic abusers are more likely to commit gun violence. According to the amicus brief that was actually filed by Brady and Giffords in this case, quote, in most recent mass shootings, the perpetrator either had a history of domestic violence or killed at least one partner or family member during the shooting. And for law enforcement officers, responding to domestic violence calls accounts for the highest number of service-related fatalities. So I wonder if you can talk a little bit more about the specific relationship between domestic violence and gun violence.
Absolutely. I'd like to just go back a little bit to talk about what we have been doing as far as a historical perspective for the DV field of work, and how that has transitioned to what we're dealing with today. 40 years ago, this entity was developed, the National Coalition Against Domestic Violence, and we took on the whole idea of what Shira just mentioned, which is individuals have a right to not be harmed, particularly by an intimate partner. And so a lot of activism, and a lot of advocacy, a lot of holding what we hoped were lawmakers accountable, but then also a lot of resources. And I shouldn't say a lot, because we're always striving to get more resources, but the ability to help lawmakers understand why domestic violence is wrong. And over this 40 years, we've seen the ebb and flow. So that's really the domestic violence context, which is it began as a women's movement strictly because we know that 85 to 95% of domestic violence victims are women. That does not exclude other categories or demographics. But we also know that we live in a society that is patriarchal and in its approach to things, as was demonstrated by both Shira and Esther, talking about the court's approach to this. It's mind-boggling, and the weirdness of it all. So it feels like we're in that ebb again, where we're trying to help lawmakers and others understand why it is so very important that someone who abuses not have an access to firearms. We know that they have been involved in something before that involved that firearm. We know that mass shooters quite frequently, in fact, most of the time we look back at their history and we know they've had domestic violence, but somehow they either got access to a gun again. We also know that a protection order is a piece of paper. So even though it's a piece of paper, a survivor needs to feel like somebody is holding the abuser accountable and that she has some kind of tool or mechanism, she, but they have some kind of tool or mechanism that they can say, help, because it's being violated, or because the PO says that the firearms have been removed, I can breathe a little more. I don't have to have the threat of the firearm. So I'd like to talk really briefly about that as well. Domestic violence is about power and control. It really is, and I can give you a 101 some other time. But part of that power and control is having access to tools that allow you as an abusive person to continue that power and control. And guess what one of those are? A firearm. I mean, we could talk about financial abuse. We could talk about all of those other tools that are used to maintain power and control over an individual. As a survivor of domestic violence and gun violence myself, I will tell you that the threat of having that firearm present was just as powerful as when I got shot. Because it was over years that there was always that threat. The firearm was kept on the refrigerator, so I would have to pass it all the time. And I cannot tell you what victims and survivors need to have to go through just knowing that with that one pull, their life can change. Abusive persons like that because it is quick and easy for them. I wish I could say it differently, but all they have to do is say, don't forget about the gun, or, that kind of thing. It is very rare that victims and survivors call law enforcement for a myriad of reasons, and we could talk about that again too. But when they do, and then they walk away because they're not allowed or they haven't been able to move forward on identifying that there's a firearm, or that the firearm needs to be removed, or any of those things that would enable that unprotected person at the moment to get the protection order that they need. And it sounds, I'm not a legal scholar. We had that conversation. But from an advocacy perspective, this feels like we are moving way back in time. And in general, it feels pretty icky, but particularly for domestic violence victims and survivors.
Thank you. And thank you for sharing all that, Ruth. So I am going to stick with the sort of going back in time and historical aspect of this.
Yeah.
Esther, I wanted to ask you, I think a lot of people might find it confusing that the Supreme Court insists on looking to history to analyze laws that are being applied to weapons that history couldn't have imagined. Can you talk about that sort of intellectual dissonance a bit?
Yeah, absolutely. And I think I just want to, before I dive into sort of the flaws of looking to history at all, I want to point out that even assuming history, and Shira was talking about this, we're talking about historical analogs, and the court did not give us a principled way to draw out analogous historical laws. So even assuming history, we don't have an easy task of figuring out what is sufficiently analogous, because like in anything, when we decide to compare two things, we need to explain and understand what would make them similar and what would make them dissimilar. And we also don't have those tools, and that's something that the lower courts are really struggling with right now. But to talk a bit more about, the intellectual dissonance, as you put it, of looking to history, I think that it's important to note that legislators never legislate to the outer bounds of their power. I think that we can look to Congress right now and all of the things that we may want them to do and assume that they have the power to do, but are not doing, to understand this concept, right? At any given moment, we can say that our legislators should be doing or not doing something, but it's not because they don't have the power to, it's because we don't believe that politically it aligns with our, worldview or what have you. But to look to history to understand the outer bounds of a legislator's power to act, and doing so by looking to the laws that they actually passed, is nonsensical. That's just not how our system works. And there are a lot of different reasons that we may or may not pass a law having nothing to do with legislative power to do so. But aside from that, I think it's interesting for a court to bind us with the past looking forward.
Yes.
because, is it really that we want our lesson from history to be that we've always gotten it right in the past and should stop learning despite new information, and despite changes in society and despite changes in technology? Like, that cannot be the way that our greatest legal minds see lessons from history. But I think that that's sort of like, in general, the intellectual dissonance that exists with appeals to history. But there are actually more specific sort of intellectual failings or intellectual dissonance in the way that the court carried that forward in these particular decisions. And I think that the common use test, which was announced in Heller's, is a really great example of that. And this basically says that despite our need to look to history to understand what our tradition of firearms regulation is, and how that binds future legislators, there are some pieces that can advance with time. And that is firearms or other protected weapons that are in common use today. In Heller, the court told us that the handgun is the quintessential self-defense weapon. It's commonly owned, and according to the court, although I think statistics don't necessarily bear this out, it's the common weapon for self-defense, which is now the focus of the Second Amendment. Obviously, handguns were not always historically the focus of any use, because handguns are a relatively new invention, particularly handguns the way that we know them today. And so this idea that new technologies get to be somehow written into our history is a really interesting idea. I think that a lot of people sort of facetiously will point to the court and say, well, if the Second Amendment protects our right to have firearms, let's have firearms that we had at the founding. And this is the court's sort of ungraceful way of squaring that with its history-focused approach. But I think concerning to all of us in this space is how that concept will be expanded, because it is rather circular in its reasoning, right? As a particular model or type of weapon becomes more and more common, its opportunity for constitutional protection grows. And that basically means that if legislators fail to act, and we were talking about legislators acting to the bounds of their power at any given moment, if legislators fail to act for too long and something becomes too common, does that mean that it is now protected by the Constitution? Is the Constitution really that variable in nature? These are sorts of questions that we're going to be grappling with in the wake of these decisions going forward. But what it does recognize is that our approaches to the Constitution must evolve over time, because if we do bind them, then we're back to that facetious joke about the colonial era musket being the only weapon that's protected. So by the court's own logic, with the common use test, we really need to be thinking about what are the parallel areas where we can carry this jurisprudence forward into the modern day. And the court gave us a wink at that when it pointed to the nuanced approach that we must be taking. And nuance was a word that Justice Thomas used in his majority opinion for unprecedented societal change. So he sort of is acknowledging that things will change, and that his test, by looking only backwards, will probably be inadequate to protect laws that even he would want to save. And so he gave us this sort of in, and obviously did not give us a lot of detail on how to apply that. And Bruin did not dive into those details. But I expect when the court picks up Rahimi, which it's likely to do, I expect we'll get more guidance as to these particular issues, because I do think that the Supreme Court, I think it's difficult to be optimistic when we talk about the Supreme Court, but I do think that there is opportunity here for the court to uphold this law, even given the ultra-conservative supermajority that we have seated right now.
Thanks. So sticking with the history piece for another minute, Ruth, I wanted to turn to you. Something that has stood out to Supreme Court watchers like myself is how inconsistently the justices how inconsistent the justices are when they look to history and tradition to interpret parts of the Constitution. So for instance, last year, the court applied a so-called originalist approach in both Bruin and the Dobbs case, which overturned Roe versus Wade. And while the court took a fairly freewheeling view of history in Dobbs, drawing from as early as the 13th century, it took a remarkably cramped view of history when it came to gun regulations in Bruin. Can you talk a little bit about that and how the court's cherry picking of historical analogs is particularly problematic in this case?
So, I can't, again, I'm not a lawyer, but what I can tell you is the real life impact and the concerns and the fear. We have worked hard since Lautenberg, quite frankly, to ensure that access to firearms would not remain a tool in domestic violence. So when you have someone, the Supreme Court, SCOTUS, coming at it with this lens that is more than problematic. So let's talk about history and what domestic violence victims used to go through. They weren't, they didn't come out and talk about it. They were allowed to be beaten by a stick no larger than your thumb. I mean, everybody's heard of these things. There weren't resources or access. So when they look at this, particularly through the eyes of Bruin and what I understand, and they overlay this historical context on it, and particularly the idea that this is an individual versus an individual, and that's in Rahimi, but the real life impact is that we go back 40, 50 years, where we have to fight for the protections of someone who has a protection order or needs a protection order because that other tool of abuse is there. Historically, even still today, I hope I didn't sound over dramatic, but this is a public health crisis. So why aren't we treating it as a public health crisis and saying we're going to do everything that we can from a society to remove those tools that allow for that abuse to happen, and we're not going to go back. And I don't know how to influence SCOTUS with that, but I don't think they understand that this will be, quote unquote, this could potentially be a ripple effect about how we have moved the whole idea that domestic violence occurs, because even today you still get naysayers about domestic violence. So it doesn't. Well, the stats prove otherwise, and the need for organizations like mine prove otherwise. Here's another really quick note to what you're asking, I think, and if I'm not answering your question, Katie, feel free to veer me another way. But I'm really concerned about the community impact. Let's go back to mass murderers, and let's go back to someone put in the question box about officer-involved domestic violence. If we're not doing what we can do at the first sign of domestic violence, we may have other impacts. Mass murders, the community that suffers greatly because domestic violence abuser went into the person's workplace and committed a crime there. It goes on and on. So whenever I think about this, I always try to remember too that this is not just about an individual. This is really about healthcare costs, productivity costs. I mean, the lists go on and on. So to put the historical lens on it, erases all of the other impacts that it could have, just erases it. And it's really bothersome. I'm being polite.
Thank you for that. You don't have to be polite. I don't always feel up to it either. So Shira, I want to go to you and just ask, so this case is pending cert, which means the Supreme Court hasn't decided whether to actually hear the case. but it should do so soon. So I'm wondering if you can walk us through the results if the court doesn't hear the case and what the potential outcomes could be if assuming that the court does, because we assume they will.
Yeah, so and that's a good point to start with, which is that it is very likely that the court will hear this case because it involves a court striking down a federal statute. And when a lower court strikes down a federal statute, the Supreme Court almost always hears the case. So we'd be quite surprised if it didn't. But if it doesn't, there are a number of consequences. The most basic one is that the domestic violence prohibitor remains unenforceable within the Fifth Circuit, which covers the states of Mississippi, Louisiana, and Texas. That would mean that individuals who are the subject of a qualifying domestic violence restraining order can still possess a firearm without violating this provision of federal law. And that would obviously endanger a lot of people. Another consequence is that this decision is already in the Fifth Circuit, is already causing widespread confusion about the enforceability of firearms restrictions in state domestic violence restraining orders. And it's causing that confusion even outside of the states covered by the Fifth Circuit. And if the court doesn't hear this case, that's just going to get worse. There are going to be lots of enforceable laws that have not been challenged, but are not being enforced because people are confused by this decision. And in a broader sense, if the court doesn't hear the case, and Esther alluded to this a little while ago, it will miss an opportunity that we think is really important to give much needed guidance about how to apply the Bruin test. And if it doesn't give that guidance, we're going to continue to see courts construing the Bruin decision really broadly and unnecessarily striking down critical public safety laws in the process. So those are three things that could happen if the court doesn't hear the case. If it does hear the case, there are a handful of potential outcomes. One, of course, is that the court agrees with the Fifth Circuit and says that the law is unconstitutional. And we all think that would be very bad. But if it does hear the case, there are a couple of scenarios, reverse the Fifth Circuit rather, there are a couple of other scenarios. So one is that it reverses the Fifth Circuit. It says that the law is constitutional, but it really doesn't say anything else. It doesn't get into the weeds of how you interpret Bruin. Or it could reverse the Fifth Circuit. It could say that the law is constitutional, and it could get into this more general discussion. And I want to highlight something about what is at issue there. Esther noted a little while ago that Bruin has to be squared with Heller. And in Bruin, Justice Kavanaugh wrote a concurring opinion, which was joined by Chief Justice Roberts. And in that concurring opinion, he reiterated a promise that's in the Heller opinion. It says that the Second Amendment, properly interpreted, allows a variety of gun regulations. So our hope is that the Supreme Court will take cert and it will reverse the Fifth Circuit, and it will recognize that promise and reiterate to lower courts that many gun regulations continue to be perfectly constitutional, and lower courts should not be interpreting Bruin in a way that strikes many of them down.
Thanks for that. And Ruth, I just wanted to give you an opportunity if you have anything you want to add about the on-the-ground impact of an adverse ruling in this case.
I just want to reiterate what Shira was just talking about, which is we already have mass confusion on the ground, even to the point that people don't understand it's just the Fifth Circuit right now. And so having needing to help people understand, calm down, we're going to figure this out, and it doesn't necessarily even apply to you right now. Once that's done, which we've done a really good job here, the hotline, other entities, as far as reaching out to advocates and ensuring that they have the best information. But what has also happened is a discussion about, well, what will this mean if it stands as it is? How will this impact not just those the Fifth Circuit, but what will be that ripple effect going out? Advocates even concerned about their own safety within their community center, wondering how they can continue to work with their first responders in their community, and what will that mean? Not just the potential lethality, let's just put that out there because that's true, but how will we serve victims and survivors when we may be afraid ourselves? How will this impact what we have finally kind of settled into, which is I can go into court, advocate for my victim or the victim, and be able to say, that firearm removal has not been enforced. I'll just put it metaphorically like that. So what will it mean to advocate even for victims and survivors now when the firearm is involved? Great concern about the potential of having this move forward in a way that is not good for victims and survivors of domestic violence and advocates in their communities. We just have to keep that in front of us.
Thanks. So I'm going to go ahead and get to some of the questions that we've had from the audience. One is, the specific question is, how would this decision affect red flag laws? But I'd like to hear more broadly about what are the other trends in the courts that could come next in the Supreme Court after this case, and how might this case affect the laws as they exist now and the cases that you see coming through the courts behind this case?
Yeah, so I think that Shira sort of made the point that applies to red flag laws or the domestic violence restraining order themselves. What this law is about is a federal law that prohibits a person from having firearms who is subject to a state domestic violence restraining order. It doesn't actually speak to the underlying restraining order as such in striking it down. And so, extreme risk protection orders, which are obviously related to domestic violence restraining orders, but still meaningfully different. I don't think that that's something that we need to worry about as an immediate direct consequences of a ruling in this case. Obviously, additional decisions that flow from this, I mean, we can't really see that far into the future. But this case does not touch on extreme risk protection orders, and a decision will not directly affect those state laws. In terms of the other litigation that we've been seeing in the Second Amendment space, in the wave of litigation that we saw after Heller, which obviously was a massive shift in the laws, as Shira talked about at the beginning, was nothing compared to what we've seen since Bruin. It is literally double the number of cases and decisions as compared to what we saw after Heller. So that should be a pretty good signal as to how much of a shift we really saw here. But in addition, I think that it tells you a good deal about how much confusion there must be in the lower courts, because really, when we see litigation, we know it's because the law is or rather a rule is unclear. If everyone knows the outcome of a particular case, there's no need to litigate it, which is an incredibly expensive and time-consuming process. We see waves of litigation when there is uncertainty in the law, because that's where we really need the court as an arbiter to decide where we fall on one side or the other. And so I think that the wave of litigation that we've seen is really sort of telling as to how much confusion there is about how to apply this test and what it means going forward. But the sorts of cases that we've been seeing sort of run the gamut. We've seen obviously sensitive place restrictions being challenged. And these are laws that prevent people who may have a firearm in certain public spaces from entering what we call sensitive places with those firearms. And in the context of the court addressing a public carry restriction like it did in Bruin, sensitive place restrictions become all the more important, but were not historically necessary because that conduct was separately regulated historically. If you think about If you need a permit to access a certain space with a firearm, there is no need to create a blanket restriction necessarily on bringing a firearm into that space. And so when we talk about like the more recent history of this kind of regulation, we're talking about sort of arriving at similar goals with different tools. And so a lot of those have been challenged. We've also seen a lot of hardware challenges, and this touches on the common use test that I had mentioned earlier. And by hardware, I mean different kinds of firearms. So restrictions on assault weapons, restrictions on large capacity magazines, restrictions on, the sorts of safety tests that are required under certain state laws before you can sell a particular firearm. And these are things like, requiring certain safety features to be included on the gun. And we're talking about pretty basic safety features for the most part, requiring that manufacturers demonstrate that the gun is not going to accidentally fire if dropped, that a 5-year-old could not pull the trigger because the trigger requires more resistance than that. So we've been seeing challenges to those kinds of laws. And finally, I think like a big category of challenges that we've been seeing come through are challenges to minimum age laws. And these are laws that set minimum ages for either getting a permit to carry a firearm in public spaces or to purchase a firearm. And this includes the federal minimum age law, which was recently struck down by a district court. And I think that the minimum age law, for what it's worth, is probably the one that's closest to the sort of thing that we're talking about here, where we're talking about a category of people that we have, as a society, have deemed to be particularly dangerous when in possession of a firearm, particularly in certain spaces. And it's similarly time bound in the way that we talk about with domestic violence restraining orders. And it implicates the preliminary question that Shira talked about at the beginning of our conversation, which is who sits among the people that are actually entitled to this right. And when we talk about young adults under the age of 21, it's not at all clear that these people are entitled to Second Amendment rights at all. That's not how they were viewed historically. And I'm not a historian, so I'll leave that to the experts, but my understanding is that the age of majority was higher in the past. So at the point that we're looking towards history, these minimum age laws have a really solid foundation in history. So that's kind of, what we've been seeing sort of flow through the courts, and by flow, I mean implode in the courts as of late.
Thanks for that. Shira, I'll kind of go to you with this one. I know that just yesterday there was a decision out of the same court that issued the Rahimi decision, the United States Court of Appeals for the Fifth Circuit, about, I had to Google this term because I didn't know what it was, but a pistol brace rule from ATF. And I'm wondering if you can talk about that case and whatever overlap it has with the Rahimi case.
Sure. So just to clarify, what the Fifth Circuit did yesterday was issue an order saying that the pistol brace rule, which is an ATF rule, it's not a statute in the same way, but that the rule, so let's take a step back. Some people had challenged the rule in district court, and the district court said that the rule could continue to be enforced. And the plaintiffs then went to the Fifth Circuit and they said, we would like you to block the rule while we appeal to the Fifth Circuit. And so yesterday, the Fifth Circuit did that, but it did it only with respect to the plaintiffs who were asking the court to do that. So as a practical matter, the rule is essentially still enforceable. It's only not enforceable against this handful of plaintiffs. But we're seeing a lot of these challenges frequently in district courts that are within the Fifth Circuit to ATF rules that provide guidance and definitions about hardware. And so just to give you another example, there's a case that's also pending cert right now, Garland v. Cargill, also coming out of the Fifth Circuit, which is about bump stocks. Bump stocks are what were used in the Las Vegas shooting. And they are extremely dangerous. They allow you to shoot a lot of people in a very small amount of time. And so this is sort of another category of challenges that we're seeing, and they aren't necessarily all focused on the Second Amendment. They're focused on other arguments about rulemaking authority and the power of federal agencies, but they all come from the same desire of certain gun rights groups to make it very difficult for the government to make all of us safer.
Yeah, thanks. I appreciate that. So we are winding down here. We have 3 minutes, and I thought I would pose a final question, and hopefully this one will let us end on a note of optimism. So I wanted to ask you all what members of the audience can do to join the fight to end gun violence and domestic violence.
I'm happy to chime in. Oh,
So
Shira,
please go ahead, Ruth.
I'm happy to chime in because that's what I do. I will ask those viewing this webinar, all of us, to make sure that not only as we're talking to anyone who's a lawmaker or in these webinars and continuing to do this kind of informational, educational opportunities for people, that we continue to do that and really talk about the protections that we have put in place for domestic violence victims and survivors, and even how insufficient those have been. And then to begin to strip away again is really, really harmful. But it's not just harmful to the victim and their family. It really does impact communities. I would also challenge us to make sure that we're using the appropriate language when we're talking about domestic violence. For instance, I saw an article the other day about a family annihilator, and I'm thinking, okay, and he used a firearm, but that's fine. But let's talk about why that happened. And I know nothing about the background of the case, but we have to be really thoughtful and critically think through what this would mean. And I think it takes all of us to make sure we're using the correct language, that we continue to educate on why this would be harmful, and then keep hope alive, so to speak.
I can jump in and just really briefly with our last few seconds say, go and vote for legislators who see gun violence, the gun violence epidemic, and want to address it. And as I mentioned earlier, legislators are not acting to the outer bounds of their power to do so. So vote for people who are interested in doing that. And vote for people who are interested in solutions outside of issues that implicate the Second Amendment. For example, my colleagues work really closely with community violence intervention groups. Funding these organizations is a really important step towards reducing cycles of violence in communities most affected. And it has nothing to do with the Second Amendment. And we won't be seeing the sort of challenges that we're seeing to those kinds of laws. So focus on voting for people who care about this issue and on funding programs that are proven to reduce violence.
And I just want to add to that, one of the most encouraging things we've seen in a post-Bruen world is state legislatures that are still interested in legislating on this issue and that recognize that they can do so within constitutional limits and continue to do so. In the last few months, we've seen new assault weapons bans in 3 states. We have seen many states pass extreme risk protection order laws. We're seeing all kinds of regulations that are critically important, and the willingness of legislatures to keep doing that. As Esther said, it's really important that we all vote for those people.
Thank you all so much. I do feel better having heard those words of optimism. So thank you, Esther, Shira, and Ruth for joining us today. Thanks to everybody in the audience. I really appreciate you all, and take care and have a great week.
Thank you all so much.
Thank you.
Thank you.
Bye-bye.